Assalamu alaikum. Welcome back to Hilaal Live. It's our legal hour. In studio, we have Brother Igshaan Higgins, who's unpacking the Divorce Amendment Act, but also with regards to Muslim marriages and how that affects our Muslim marriages in South Africa, giving us lovely context in terms of how Islam has evolved over the years, in terms of how Muslim marriages. Igshaan, Jazakallah once again for coming into studio. Really appreciate it.
Yourself and to the viewers.
With regards to, we touched briefly on maintenance and, in terms of a relief that the wife can get during this divorce procedure. Now, when it comes to the calculation of maintenance, because, when a couple is married, the money is split and, allocated accordingly for expenses. Somehow, during a divorce, that can go awry, during this process, because there's a lot of emotions involved as well. What do courts look at during this process?
I think first we must look at, once again, I like to give context. Previously, we had a situation where if somebody says, and before I get to the issue of maintenance, let's just get to the issue of assets.
Okay, all right.
So when a woman does not have anything on her name, and all the years, even she's been working, you've mentioned earlier, what if somebody works?
Right.
Because in that instances, normally what happens is if the house is on the husband's name, the husband then pays things like the bond.
The bond.
He pays the rates, he pays all that. But the woman then pays for the disposables,
Right.
the consumables,
Yes.
the electricity, the groceries, the whatever. But all her money goes into the maintenance of this household.
Right.
So of course, many years ago, well, not that many years ago, but when somebody comes to our offices and says, listen, I don't have anything on my name, I don't even have money, what do I do? Then we would, at that time, create a fiction.
Okay.
That fiction would be that if both parties started out with nothing, when people get married, they're young, none of them have assets. And then, of course, there is, then we create a fiction called a universal partnership.
Okay.
And to say, well, you have a universal partnership, which means you're probably entitled to 50%. Knowing full well, in our case, it's a fiction.
Right.
Because at the time, universal partnerships was only applicable to commercial transactions.
Okay.
So, of course, we knew if we had to get to court, we can issue summons on the basis of a universal partnership. But we knew if we get to court and we have a clever judge sitting there, that clever judge will simply say, this is a commercial issue. Did you people discuss it? Because contracts have certain elements.
Of course.
You need to discuss a contract and you need to comply with the elements. So what we then did, as I say, with the hope that this thing never gets to court, we can maybe settle the thing, and which we did.
Right.
99% of those cases were settled. But until one day, there was a case in the Eastern Cape. The case was Butters versus Nkora.
Okay.
It wasn't a Muslim case, but it was a couple that lived together. And this couple lived together for a number of years. He built up his business. He had an electrical business, and he became quite successful. Then, after this period, let's call it 8 years, this lady goes on holiday. Right? And then she returns a day before she was due to arrive.
Right.
And when she arrives there's all these small children running around in the house, and there's another woman lying on the couch. And she comes in and says, but now who are you? And so the woman said, no, this is my husband's house.
Sure.
So the same gentleman married another woman, had children with her, without her knowledge.
Right.
So, of course, everything was in his name, and he was obviously he was okay financially. But then this brave woman, Mrs. Nkora, she then took him on and then claimed 50% of his assets, based on the fact that she helped him, he started with nothing, and they also used the term universal partnership.
I see.
But in this instance, the court ruled that they will accept a universal partnership in the realm of marriage, extending that realm from that of commercial to marriage.
To marriage. Wow.
And in that, but they didn't give her 50%, they gave her 30%.
Okay.
But then, of course, we were elated. The Muslim lawyers here in the Cape, we were like, how are we going to use this case now? And we did. Because now we had judicial precedent that supported this thing. So on that basis, when we talk about quantum, and a woman that doesn't have anything on her name, the best version of it would be ask for 50%.
Right.
Even though a marriage in accordance with Islamic rights is deemed to be out of community, where your assets remain your assets in my. But let's talk about the contribution. The contribution to the accumulation of wealth of that particular husband. So now we're saying, claim 50% and let's see where we get to.
Right.
Because there's now a clause in the new act. If we fast forward now to the new act, in terms of the Divorce Act now, the court must look at what is fair and equitable.
Okay. So coming back to the question of maintenance, people are going through the divorce. Obviously, the mother can apply to the courts for maintenance, for the upkeep of the children. In the event that maintenance or the divorce goes through and a maintenance agreement is put in place, how long does either spouse have until they maintain the children? Until what age?
Well, children must be maintained until they're self-sufficient.
Okay.
So even though in South African law, the age of majority is 18,
okay,
but it doesn't stop there.
All right.
It now you must evaluate whether the child is studying, whether the child has the potential to study, and if the child is self-sufficient. So if the child is still studying, and let's say the child studies till the age 26,
right,
then you still have a duty of support to support that child until such time that the child is self-sufficient.
So what if the child reaches the age of 21, doesn't work, can't find work, can't study? What happens in that instance?
Well, you can make an argument to court that the child is not self-sufficient and he still needs parental support.
Okay.
So the fact that the child becomes 18 does not exonerate the party that must pay maintenance. The test is really self-sufficient. The child must be self-sufficient.
Right, right. Does it take into consideration both parents' incomes? Should there be an income from both sides?
No, of course it always does. If you even go to the maintenance court, they will look at income from both sides. But the test is normally, how do you keep the child in a not in comfort, but in terms of how what they were used to.
Okay.
And the father can't be a millionaire, but he gives his child a pittance to live on. So the courts look at all these things, all these factors, take into account in order to arrive at an amount. So there's not a one-size-fits-all situation. They need to take all the factors into account.
Right.
Which just brings me to one other thing, and I think this is quite an interesting point. A lot of people, a lot of men especially, that must pay maintenance will plead poverty. They will say, I can't afford it, I'm not working. And then the next question the maintenance officer will ask, but how are you supporting yourself? So, no, I depend on my parents. The minute they say that, then that parents can be called into court. And a magistrate has the right to actually make an order against the grandparents or a judge.
Right, for maintenance.
For maintaining the grandchildren. So it's a very effective remedy. If somebody comes up with the argument to say, but well, I can't support the children, I'm not working, or whatever they say. And or if in another scenario, if the person is not working, then but they're driving a nice car and they're living in a nice house, or they say they can't afford. Best thing would be subpoena the application for the bond, subpoena the application to purchase the car, because those two documents will reveal a lot. Yeah,
where the income is coming
from.
Where
that income is coming from. So I think, there's a lot of, we didn't even get to the part where we're going to speak about the maintenance of surviving spouse, but I think maybe we're going to do that in another program.
I think so too. There's so much to unpack, and I think we've done so well already, and I'm sure our viewers are very, grateful for the information that you've passed on, because it's now, gives them a lot more light and a lot more information when going through any situation like this as well. Always a pleasure having you in studio. Inshallah, we can continue next week, or if not the following week, we will unpack further with regards to the Divorce Amendment Act as well. Have a great evening. Assalamu alaikum.
Shukran to you and shukran to the viewers, and assalamu alaikum wa rahmatullahi wa barakatuh.
Salam. That's Brother Igshaan Higgins in studio, always giving us much needed information regarding our legal system. Thanks for joining us from the Cape Town team, Sohail Barnes, Mohammed Parker and myself, Luqman Shadrack. Have a great evening. Assalamu alaikum. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to another edition of Hilaal Live. Thanks for joining us on Channel 347 on DSTV. It's Wednesday, means that it's our legal hour, and back in studio our attorney, Igshaan Higgins. Assalamu alaikum.
Wa alaikum salam wa rahmatullahi wa barakatuh to yourself and to the viewers.
Jazakallah so much for coming into the studio. Over the last couple of weeks, we covered the Divorce Amendment Act, and we had some very interesting information come through from yourself and Brother Faisal that was in studio. But we want to continue that and take it just one step further in terms of, but before we get there, maybe explain to us what is the state of marriages in South Africa?
I'm assuming you're referring to what is, where are we at?
That's correct.
With the different types of marriages now, and more particularly the Muslim marriages.
Muslim marriages, yes.
So, in South Africa we had a system of law regulating marriages. Mm-hmm. And that was in terms of the Marriages Act and, of course, the Matrimonial Property Act. Mm-hmm. Now, in terms of the Matrimonial Property Act, you had like three types of marriages. One was in community of property, one was out of community of property, and the other one was out of community of property, but including the accrual.
With accrual.
Okay.
Or cruel.
Accrual, yeah, could be. And of course, that was only three types of matrimonial regimes. Mm-hmm. Now, of course, Muslims were not prohibited from getting married in terms of the civil law. Yeah. So you could get married in terms of the Matrimonial Property Act, and then of course you are subjected to the outcomes of whatever the outcomes is for those three matrimonial regimes. Mm-hmm. But Muslim marriages were not recognized. Right. And I mean, we have articulated that already, mm-hmm. That Muslim marriages were not recognized, and that for 350 years, there was a system of non-recognition.
Right.
So remember when the first Muslims got here, Islam was technically banned. Mm. I mean, and as I said, there was a placard in 1642 that technically banned Islam. Mm. But of course, when the Muslims came to the shores of the Cape, either as slaves or as convicts or as indentured laborers, and of course as exiles. Mm-hmm. When they got here, they couldn't practice Islam freely. But Islam was tolerated at the time by the Dutch, because of course they needed the Muslims to provide the labor and the skills. So of course they turned a blind eye to the practice of Islam.
Right.
And in addition to that as well, if a slave became baptized, a Muslim then becomes baptized and he says he wants to embrace Christianity, then the master had no choice but to have him baptized. But at the same time, whilst he is baptized, he would also have the right, he acquired the right to buy his own freedom.
Okay.
And of course, the children born of a baptized slave, they would not be slaves, they would be born free. So therefore it was in the interest of the farmer or the master, the slave master, to keep people Muslim. Because whilst you are Muslim, you don't have the right to buy your own freedom.
Right.
And number two, your children are also born into slavery. So in that respect, Islam could survive. It was one of the big factors that led to the survival of Islam on the southern tip of Africa, other than people's faith, of course.
Of course, yeah.
And various other factors, but that was one of the big factors that kept Islam going. So, of course, since that time, there was non-recognition of marriages. But, of course, people still practiced in the sly um, until, 1994, there was a promise that now we're going to have Muslim marriages regularized and recognized. So there was a lot of interaction at the time through the South African Law Commission, through various lobbying bodies to get Muslim marriages recognized.
Right.
There was a judge of the Supreme Court of Appeal, Judge Nafsa. He convened a meeting. I remember attending a meeting with him in 1996. Mm-hmm. And it was promised there that, we're going to have a Muslim Marriage Act. We must just be patient, and of course it's going to be drafted. And the South African Law Commission convened, the study groups, but nothing came of it because of the whole, because Muslims couldn't agree on what should be contained in that particular bill to make it an act. So, of course, we know there was a whole lot of cases. We articulated that last week. And then, of course, there was the Women's Legal Center case that compelled the legislature to pass legislation.
Right.
So the easy way out was to not concoct or construct a Muslim marriage bill or an act, but to simply add Muslims to the Divorce Act. Mm-hmm. So that was the Divorce Act of 1979. So now it applies to Muslim marriages. Mm-hmm. And because of that, Muslims have now the right to go to court to get a divorce.
Okay.
And as we also said last week, we're not quite sure how it is going to be possible for a non-Muslim judge to pronounce a talaq or a fasakh on a Muslim couple.
Right.
But my guess is that they will probably rely on an assessor, a sheikh or imam, to come in to look at the religious aspect of that particular talaq or fasakh, and on that basis pronounce on it. And so if the imam gives say, okay, this talaq is, the application is valid, and we're going to grant it, or the fasakh is valid, we're going to grant it, then the judge will make that an order of court.
Okay.
So I'm assuming that is the case, because the process has not been confirmed yet. So the law is there, but now it's about building up the jurisprudence to actually get to a point where people are comfortable.
Of course.
In bringing an application before a judge. And in all probability, you're going to be appearing in front of a non-Muslim judge.
Absolutely. So now that Muslim marriages are recognized in terms of the Divorce Amendment Act, okay, can a woman ask for interim relief whilst the divorce is pending?
So, thanks for that question. Yes, of course. We've always had what we call a Rule 43 application. It's interim relief. So whilst the divorce is pending, so let's say the woman has issued summons now against the man, saying, I want a divorce. Under normal, so even before the Muslim marriages were recognized, been recognized, then a man can actually still be liable then for the interim maintenance. So there's a few types of interim relief that the Rule 43 can provide.
All right.
One is interim access of the children, interim custody, interim maintenance for the spouse,
yes,
also interim maintenance for the children, and the big one, costs.
For the case as well.
Yeah, so let's say a practical example, a woman has maybe been a housewife for however long, for say 30 years. The children are fairly big, or maybe not even that big, maybe teenagers. And she hasn't worked because she was doing the homemaking.
Right.
She was looking after the children, she was doing the washing, the cleaning, whatever is needed in the house. So the man could go out, he could go work, he comes home to a clean house, he comes home to to a setup that's conducive for the raising of children within the family structure. And so then what normally happened was a man has the house in his name. The woman doesn't have the house in his name. And when it comes to divorce, the man will say, yeah, but she didn't work. Now, even though I'm a man, I find that extremely offensive. Because it's not acknowledging that being a person looking after a household
is a job in itself.
That is a bigger job, I think, than going to an office.
Right.
So I think it took a lot of education. And I think we must still do a lot of education to educate men. That is in itself a job, because you can actually, you can monetize that. If you take how much you would have paid a domestic for a period of 30 years, a witness for a period of 30 years, a launderer for 30 years.
Somebody to make food at home.
Yeah, and it's so many activities encompasses, the homemaking process. Now, if you add up all those things, I mean, it's a lot of money.
And it also prohibits the mother from working because it's a full-time job, looking after the kids in the household. So it actually prohibits her from actually earning an income.
Exactly. So
although we have some mums that work and still do that.
Yeah, well, that's double trouble, as you say. But I think that's something that people need to be educated upon. But we are going to be dealing then maybe after the break.
Yep.
In terms of the split of the asset and how it actually works.
Okay, brilliant. In studio, Brother Igshaan Higgins chatting to us. We expanding about the Divorce Amendment Act, and you could welcome to join us on the WhatsApp line 079-085-2511. Let us know your questions, and we'll pose that to Igshaan. We're going to take a short break. When we come back, we continue with Hilaal Live.